guys. Appeal in the matter of British Telecom PLC and Her Majesty's Treasury and another. My lords, my ladies, I appear with Mr. Campbell and Ms. Rooney for the appellant, British Telecom. My learned friend, Ms. Demetriou, and Mr. Johnston and Mr. Halliday appear for the respondent, Her Majesty's Treasury, and my learned friends, Mr. Hilliard and Mr. Steele, appear for the BT Pension Scheme trustee, the intervener. If I can first just ask what the court's been able to read. I'm conscious that there's a certain amount of technicality in the case, and also that the court has a considerable degree of expertise in the area, and I just wanted to know, I assume...
We've obviously read the skeletons,
yes, and the
judgment, and we've read the sort of background note
yes.
as well. We've read all of that. I'm afraid so far as the evidence, there were various references to the evidence.
Yes.
Some of the cross-references weren't correct with the bundles, which
yes.
leave that aside. So some have read more than others, but
yes.
in any event, we would expect, if we want to rely upon particular parts of the evidence, you'll refer us to that.
My lord, I will do that. If I can first of all just refer the court to our skeleton argument at Core Bundle 2. At page 4, you can see between pages 4 and 6 that there is a short summary there of the 5 grounds of appeal and of BT's case under each head. And so if the court's looking for an easy case in a nutshell of what our contentions are on the appeal, you will find it there. The other matter I want to address at the outset is the relevant statutory framework and history, which the court will see is summarised in an agreed note, which is at tab 4 of Supplementary Bundle 1. So if I can invite you to turn that up.
I've taken all these out of the bundles. So.
The arrangement of these bundles is quite spectacularly unhelpful. I have to say that is not our fault. It's the result of faithfully following the requirements of CPR Part 52, but it does result in things not being in chronological order, which is quite irritating. Anyway, so if we can just start by having a look at this note. As the court will be aware, these proceedings arise out of changes to the state retirement pension that were enacted by Parliament in 2014, in the 2014 Pensions Act, and came into effect in April 2016. As a result of those changes to the state pension, the Treasury has decided on an interim basis to provide full indexation of the guaranteed minimum pension, or GMP element, of the occupational pensions of public sector employees. It's done that in order to honour historic commitments that were made to members of public sector pension schemes by previous governments in the government's capacity as their employer. And that context brings into relief what we submit is an important distinction that arises in this case. And that is the distinction between the role of the government when it is making and implementing general public policy applicable to everybody through legislation promoted by the government and enacted by Parliament, and the role of the government when it acts as an employer, fulfilling its obligations to its own civil servants and other public employees. When the government is performing the latter function, addressing its own particular relationship with its employees and officials, there is no good policy reason why it should act in such a way as to impact other employers operating in the private sector, and particularly no good policy reason why it should do so in a selective way. On the contrary, there are, of course, very strong public policy reasons why it shouldn't act in that way. As we say in the agreed note, for many decades prior to April 2016, there were two tiers of state retirement pension. There was the basic pension and then an additional pension, or AP, which was earnings related. Employers and employees could choose to opt out of parts of the AP by operating a contracted out occupational pension scheme. And such a scheme had to provide at least a statutory guaranteed minimum pension, or GMP. And employers who chose to do that would pay lower national insurance contributions. Initially, under that system, employers were not required to provide any degree of uprating or indexation of the GMP element of the occupational pension to account for inflation. The value of the GMP was topped up annually by the state through the state pension, through the mechanism of the additional pension. And the court will see the methodology by which that was done is summarised at paragraph 4 of the agreed note. And I don't propose to go through it in detail. So that was the initial system. That system was subsequently modified, and under section 109 of the Pensions Act 1993, occupational pension schemes that had contracted out were themselves required to provide for increases to the GMP accrued after 1988 to account for inflation, up to a maximum level of 3% per annum. And you can see that at paragraph 5 of the agreed note. So the system was, now after 1997 there was no more accrual, so we're talking about a fixed period of time. So the system was that contracted out schemes had to provide the GMP. They didn't have to uprate the GMP accrued before 1988 for inflation at all. That was looked after by the state through the AP. They did have to provide at least some element of uprating for inflation for GMP accrued between 1988 and 1997 up to a 3% cap. But if inflation in any of those years was higher than 3%, then the government again would make up the shortfall through the AP mechanism. So the overall effect of the statutory scheme was that the burden of uprating the GMP to account for inflation was shared between the state through general taxation and the AP and employers of the individual occupational pension schemes through the mechanism operated under section 109. Of course, that sharing of the burden is theoretical in the case of public sector schemes because the entity providing both elements of indexation in their case is the same, it's the state. So that was the old system. And that system changed fundamentally with the enactment of the Pensions Act 2014. Parliament decided to simplify the state retirement pension by abolishing the two-tier system. Instead, there would henceforth be a single level of state pension, paid at a level somewhat higher than the basic pension. So for many people that would mean an increase in their retirement entitlement, but for many others it would be a decrease because it would be lower than the old additional pension. to which they would have been entitled. Because the additional pension had been abolished, the element of indexation of the GMP, which had previously been provided through the AP, was also abolished. Now, at this stage, Parliament could have decided to plug that gap by putting a new legal obligation on employers to provide full indexation through their own occupational schemes. In other words, it could have enhanced the system operating under Section 109 of the 1993 Act, so that employers had an obligation to uprate the whole of the GMP element for the whole period without any 3% cap. But that is not what Parliament did. Parliament's policy, reflected in the legislation, was that no new legal obligation should be imposed on individual occupational pension schemes to uprate the GMP. This was a part of the overarching government policy at the time against the imposition of heavier regulatory or financial burdens on business. The explicit policy was that it was up to individual pension schemes to decide how they would react to the change in the legislative framework, depending on the rules of their particular scheme, and depending on what assurances or commitments might have been made to members of those schemes in the past by the employers operating them. Now, in that context, the government recognised that in its capacity as employer, no longer wearing the government hat, but wearing its employer hat, it had a problem with its own occupational pension schemes. And the reason it had a problem was that historically, commitments had been made by previous governments to members of public sector schemes to the effect that the entirety of their pensions would always be uprated to protect them against inflation. And because of those commitments, the government recognised that it had to put in place some mechanism to ensure that those commitments and assurances made to public sector pension scheme members were honoured. And that is paragraph 17 of the agreed note. That policy is not controversial and is not the subject of the challenge in these proceedings. The challenge, as the court knows, is not to the government's determination to honour its assurances to the public sector scheme members. It is the method by which the government has chosen to do that, presently on an interim basis. By the decision challenged in these proceedings, the Treasury has chosen to issue a ministerial direction under section 59A of the Social Security and Pensions Act 1975 in order to fully uprate the GMP element of public sector pension scheme members where previously that would have been dealt with under the AP. Because of the wording of section B of BT's own occupational pension scheme, the effect of that ministerial direction is that that right to full uprating is to be read across and will apply to BT's own section B pension scheme members. BT is now committed to providing the same indexation, at least to members retiring up until 2021, because this is at present only an interim decision. And that is so even though BT's section B members do not fall within the class to whom the historic assurances and commitments were made, and do not therefore fall within the scope of the policy that the government was seeking to implement by making this decision. Now, the effect of this decision is to impose on BT an additional cost of some £120 million. If in due course the same method is adopted by the Treasury for the long-term future, not just an interim period, the liability imposed on BT will be hundreds of millions greater than that. None of BT's competitors will face the same costs imposed by government, because the government's overarching policy was that it wouldn't require occupational schemes to operate in this way. And in those circumstances, BT's complaint and its judicial review challenge before the Divisional Court, which it maintains before this court, is that the decision by the Treasury to adopt this method was unlawful. The Treasury chose this method even though an alternative was available to it, which would have fully implemented government policy, would have indexed the pensions of public sector scheme members, honouring the commitments made to them, but would not have had a read-across impact on BT's scheme and members to whom no such commitments had been made. And the means in question was to amend the rules of the Principal Civil Service Pension Scheme, the PCSPS, itself, using powers to do that under sections 1 and 2 of the Superannuation Act 1972. If the scheme rules themselves had been amended, instead of a ministerial direction being issued under the 1975 Act, then that would not have had a read-across impact on section B.
What would the amendment have been?
The amendment would have been an amendment to the PCSPS to provide for the uprating of the GMP element of PCSPS members' schemes insofar as that was not provided for under section 109.
And who would make that decision?
That decision can be made by the Minister for the Civil Service or any minister to whom that power has been delegated under the 1972 Act. I'm going to come to the details of how the Act...
All right, I mean,
Yes.
I'm just thinking about changing,
Yes, Lord.
changing the principal civil service scheme itself,
Yes,
pension scheme.
yes,
You're going to have a provision in there which provides for increases
yes.
to all pensions, some pensions. How is it going to? What's it going to look like?
What it would look like, my lord, is an increase defined by reference to the GMP and such part of the GMP that wasn't increased for inflation in accordance with an order made under section 109 of the 1993 Act.
I mean, the way the statutory provisions work
Yes.
is 59(1) provides for the Minister for the Civil Service. Is it still the Minister for the Civil Service? Or is it somebody else, the Treasury?
Well, my lord,
Under section 59(1), what is it? The version that we have,
yes, I'm not aware that it's different.
is there a Minister for the Civil Service?
Unless it may have been delegated, my lord, but
It's now the Treasury.
So there's been a statutory amendment, is there, of some sort? Section 59(1)'s been amended? Or to that
it may
extent?
be.
Can I come back to that point, because I need to take instructions
All
on
right,
it.
well, I think we need to understand how these work. So I've just said I got the statute
Yes, Lord.
framework right. The section 59(1) starts off, where by virtue of section 151 of the Administration Act, a direction is given that the sums mentioned in section 151C
Yes.
of that Act are to be increased
Yes,
by a specified percentage. So
Yes.
that's down.
Yes.
Then the next bit is, the Minister for the Civil Service shall,
yes, it's a
mandatory,
duty. Yes,
by order provide at the annual rate of an official pension, which this is under the scheme,
yes.
may, there's now, it's rather confusing.
Well, it's only may because it's in relation to qualifying conditions. Well, can we come to the detail of the statutory construction a little bit later?
Well, the only reason I'm mentioning
yes.
this is because I'm not sure it's actually been fully explained to us exactly what the amendment to the PCSPS would be. because I need to kind of envisage, you know, the form of the trust, and who's going to make that decision. Is it going to be under the terms of that trust, that scheme, under the terms of the scheme, the principal civil service penalty, under the terms of that scheme? Who is going to make that decision? Is it going to be the Minister for the Civil Services? Is it some other person? I don't know what that scheme looks like.
I understand. Well, can I come back to that a little later? I just want to approach it piece by piece. And your Lordship will bear in mind, of course, that the nitty-gritty of how exactly the matter would be drafted is obviously a very important question, but it's a question subsequent to the question whether there is a power to implement such an amendment at all, and whether doing so would be unlawful. And one of the problems in this case is that the government has never considered that question because they concluded at the threshold stage that there wasn't a power to do it. Now, I'm happy to...
What I'm trying to say is I think it's all mixed up together, because what you're looking at,
Yes,
you've got a switch-on mechanism in 59.1.
yes,
You've got an automatic switch-off provision in 59.5. And then you've got a completely separate provision in 59A, which is a switch-on provision. Your complaint is actually about the switch-on provision, because 59A is read across into the PT scheme,
yes,
and that triggers it.
yes.
So what you're complaining about, as I see it at the moment, is using the mechanism of 59A for a switch-on. And so what I'm trying to understand, why I'm saying it may be all connected together, is the question is whether or not, if you did amend the scheme in the way you're suggesting,
Yes.
there will be no substantive difference of any kind between 59A and the terms of the scheme.
Yes, I understand.
That's why
I
I'm not sure
understand
it's a separate and subsequent question.
I understand, my Lord, but just
I
to
don't think
prefigure what I'm going to say, just to prefigure what I'm going to say, our essential point, which your Lordship will have picked up from our skeleton argument, is that there is an essential difference between the powers to make and amend a public sector pension scheme under the Superannuation Act, which are very broad powers to make the scheme in any terms that the Minister chooses, and the duties under Section 59. And our submission is that what Section 59 is doing is establishing a duty on the government to uprate public sector pensions by a particular specified minimum. What it is not seeking to do is to constrain the powers that the government has to implement whatever terms it pleases under the terms of its pension scheme. So, for example, let us say that you have a situation in which the government decides that for the purposes of the uprating of social security benefits and therefore public sector pensions, it's going to use CPI as a measure of increases in the cost of living. So an order will be made under Section 150, which then reads across into Section 59, saying that all official pensions must be uprated in accordance with CPI. And let us suppose that one public sector group, that let's say firefighters, go on strike and say we insist that we're entitled to RPI, which is more favourable to us. And in order to settle the industrial action, the government agrees to provide inflation increases to firefighters on the basis of RPI. That would not be done, and it couldn't be done, under Section 59, because Section 59 is a duty to use the same methodology that you're using to uprate social security benefits. The way it could, and in our submission would appropriately be done, would be through an amendment to the public sector scheme for firefighters under the Superannuation Act, giving them a specific entitlement to uprated in accordance with RPI, because that would be on the basis of a particular agreement or commitment or assurance given to them.
Yes, I think the only point I was trying to make was, I don't think your problem's with 59, because 59.5 automatically cuts.
Oh yes, no, of course it's 59A.
It's not 15, your problem isn't with 59
Absolutely.
at all, because if you just left 59 on its own, there would be no
course.
increases.
Of course.
It's 59A.
Of course it is, my lord. And I want to come in detail to look at what function 59A is providing in the statutory scheme, because in my provision it's quite a limited one, and it's not the function that the Divisional Court said it provides. But what I was just submitting to your lordship is why we say that those two different statutes are performing different functions. One is a duty to set an across-the-board minimum, and that's the duty that crosses over to BT. And the other is a power to set whatever pension scheme rules for individual schemes that the government deems appropriate, and that would include individual advantageous terms based on particular assurances or commitments. Sorry, my lord, that was a slight digression.
Yes. My fault.
So we call the BT proposal the PCSPS amendment route. That's the phraseology I'm going to use. And our case is that the Treasury, in the decision that we've challenged, wrongly rejected the PCSPS amendment route on grounds which included two key errors of law. The first error was that the Treasury wrongly concluded that it would be ultra vires to adopt the PCSPS amendment route. And that has been put in two ways. First, it's said that the power under sections 1 and 2 of the 72 Act doesn't extend to increases. And secondly, it's said even if it does, it would be unlawful to use it for this purpose because it would be a Padfield improper purpose. So that's the first error, and it itself encompasses two limbs of argument. The second error is that the Treasury wrongly believed, in our submission, that implementing the PCSPS amendment route would interfere with property rights of BT Pension Scheme Section B members, and that interference would be unlawful as a breach of the Human Rights Act unless it could be shown to be justified in accordance with Article 1 of the First Protocol. And in our submission, both of those propositions are wrong as a matter of law. The government did indeed have the power to implement the PCSPS amendment route through the Superannuation Act, and doing so would have been perfectly proper, and doing so would not have interfered with any property right. On that basis, we submit that the decision cannot stand because it's flawed by those errors of law and therefore must be remitted for reconsideration on a correct legal basis, on the basis that the Treasury considers it, appreciating that it has the power to do what BT suggests, that it would be proper to use it, and that there would be no interference with property rights. In response to BT's claim, the Treasury has accepted that the effect of its decision on BT was inadvertent and wasn't a part of its policy intention. We say that's important.
Sorry,
However,
could you just repeat that again?
yes, it's accepted by the government that the read across was inadvertent, that the policy was intended to protect public sector scheme members to whom the assurances have been given, and that didn't include BT members. That's common ground. However, the government contended that in fact its decision was made on what it calls, quotes, pure policy grounds, which are separate and severable from the legal propositions that I've just outlined. Simply because it said it was considered to be inappropriate to favour BT's interests over those of the scheme members. It also, for good measure, contended that BT's proposal was ultra vires and did interfere with property rights. That was how the case lay until a very late stage in the proceedings. It was 9 days before the hearing date when we received a further witness statement, further disclosure, and a further note from the defendants. And the disclosure consisted of some entirely new documents and some documents, including the submissions to ministers in relation to the consultation that had previously been provided to us in a redacted form and that were now unredacted. And that new disclosure showed that the belief that BT's proposals would interfere with property rights had played a much more central role in the government's decision-making process than it had hitherto acknowledged in the judicial review proceedings. It therefore gave the government a bit of a difficulty on its primary case, which was this was a pure policy decision, nothing to do with property rights. Perhaps in order to...
So you, as part of the challenge, the judicial review challenge, you require the court to say that there would be no interference with property rights.
Yes, that's right.
Can the court properly do that without the beneficiaries being represented?
Well, my lord, the basis on which this was argued below was that it could, on the basis that it would be argued on the footing that for the purposes of these proceedings, nobody is challenging the wording of Section 10, Rule 10.2 of Section B of BT's pension scheme. But that would not preclude beneficiaries from arguing it should have a different meaning in other proceedings.
Well, all right, let's not get bogged down in that too much now, but obviously it would be unusual, I think to say the least, for the court to adjudicate on the rights and interests of third parties who are not properly represented. In this particular case, it's being decided that the trustee, who might otherwise represent the interests of the beneficiaries, is not doing so.
Yes. But, my lord, of course, the context in which this arises is a challenge by BT to a decision made by the government.
Yes.
And the question is whether it was unlawful for the government to conclude that there was an interference with the scheme members' rights on the basis of the material available to it at the time. Now, if the government were to reconsider its decision, it wouldn't be precluded from taking a different view. It would depend on what material was put before it. The question is whether the decision that's been made, the public law decision that's been made, on the material available at the time can stand.
I'm just trying to identify the issue.
Yes.
So, would a better way of putting the challenge on this ground be whether it was irrational of the government to take the view that what was proposed might interfere with the A1P1 rights
No, my lord.
of the beneficiaries?
No, my lord. We put it higher than that. We say that it was unlawful. There was an error of law in the government's conclusion that this would interfere with A1P1 rights, because there is no legal basis for it. What your lordship knows is that the way it's argued is that a property right arose in this way, that Rule 10.2 says that members of Section B have a right to increases to the PCSPS made via a ministerial direction under Section 59 or 59A. The argument that's mounted is that they had a legitimate expectation that no increases would be made to pensions under the PCSPS by any route other than Section 59 or 59A. That's the argument, and that is an accrued property right. Now, we say that is an error of law. It's not based on any promise or assurance that's identified. It's based on what we say are legally erroneous propositions, first on what will amount to a legitimate expectation, and also what the statutory scheme provides. So, my lord, whether or not somebody could argue in the future that there was some other kind of property right arising on a different basis is not a matter for this court. The point is that the property right that's been identified and found against BT, in this case by the Divisional Court, in our submission is based on an error of law. Now, so in those circumstances of this very late disclosure showing that the alleged interference with property rights had played a much more central role than the Treasury had previously accepted, the Treasury at that stage, very shortly before the hearing, ran a new defence contained in a third witness statement of Mr. Kirk and in a note that was provided to the court, in which it was said that in fact BT had never put forward the PCSPS amendment route as a freestanding proposal during the consultation process, that had never been advanced by BT until its pre-action protocol letter was sent, and that before that BT's PCSPS proposal had only been made in conjunction with another proposal called the statutory override, which BT accepts would indeed interfere with Section B pension scheme members' rights. Now, the statutory override proposal was a proposal that the government should legislate so as to permit private sector schemes such as BT to alter the rules of their pension schemes so as to break the link between the indexation of their scheme members' pensions and uprating provided under sections 59 and 59A. So that would be an alteration of the scheme rules that materially affected the rights of pensioners, and BT accepts that that would indeed be an interference with property rights. So the argument that was then mounted by the Treasury was that that was always a necessary element of BT's proposal, and since that would interfere with property rights, then the argument that the PCSPS wouldn't was immaterial. So that's how matters lay when the court came to make its decision. And the Divisional Court found in favour of the Treasury on all 5 of the points I've just outlined. It's fair to say that we lost, my Lord, comprehensively in front of this court. And my task is to persuade your Lordship and your Ladyship that the court was comprehensively wrong. And
I think you have to show that they were wrong on all 5.
On all 5. That's correct, my Lord. I have to show that they're wrong on all 5. We submit that the Divisional Court made 2 findings of fact that are unsustainable on the evidence that was before it. First, the finding that BT had not advanced and had not been understood by the Treasury as advancing the PCSPS amendment route as a freestanding proposal. And second, that the Treasury's decision was taken on pure policy grounds that were entirely separate from and severable from the conclusions on vires and property rights. We say that both of those conclusions is unsustainable. In making those findings, in our submission, the court left some important evidence entirely out of account and interpreted other evidence and materials in ways that their language cannot reasonably bear. Of course, as is usual in a judicial review, all of the evidence before the court was in written form. It either consisted of contemporaneous documents or of written witness statements, which are before this court. And the hearing lasted 2 days, just as this hearing is listed for 2 days. In those circumstances, we do submit that this court is just as well placed as the Divisional Court was to analyse the evidential material. And we invite you to conclude that the court's findings on those 2 issues are wrong. The relevant legal test, as the court will know, is that set out by Lord Sumption in the, I'm not sure if it's Volcaf or Volcafe case. I think Volcafe sounds like a nice little joint in Islington somewhere. It's an Authorities Bundle 3, tab 57, paragraph 41. I've got two.
I've got two.
Yeah, I think it's still tab 57.
My lord, mine are in 3 volumes, but it is tab 57.
Yes, it's now bundle 2.
If you would go, please, to paragraph 41, it's page 1752 of the volume. This court has on a number of occasions pointed out that while an appeal to the Court of Appeal is by way of rehearing, a trial judge's findings of fact should not be overturned simply because the Court of Appeal would have found them differently. It must be shown the trial judge was wrong, fundamentally misunderstood the issue or the evidence, or plainly failed to take the evidence into account, or arrived at a conclusion the evidence could not on any view support. Now, just pausing there are some adverbs used by Lord Sumption, which in my submission, with great respect to his lordship, are OTOs.
Sorry, which paragraph is it?
Sorry, paragraph 41, my lord.
Oh, yes, I see. Thank you.
If the judge has misunderstood the issue or the evidence, or failed to take the evidence into account, or arrived at a conclusion that the evidence could not support, that will be sufficient. The adverbs in my submission are not adding anything of substance to the test. And he then makes the point that there's a world of difference between the impression evidence makes on a judge who's followed it as it was deployed and the impression an appellate court derives from cold transcripts. Now, that, of course, is a key distinction between the type of case Lord Sumption is there considering and this case, because this is not an appeal from a trial where oral evidence was heard. It's an appeal from a judicial review where all of the material is before this court in exactly the same form that it was before the court at first instance. And Lord Justice Sales, in the case of Smek Properties, which is at tab 49, paragraph 29, discusses appeals against findings of fact and judicial review, and he says it'll often be appropriate for this court to give weight to the assessment of the facts made by the judge below, even where it's been made on the basis of written evidence, also available to this court. The weight to be given to the judge's assessment will vary, depending on the circumstances of each particular case, the nature of the findings of the factual assessment, and the nature and range of evidential materials bearing upon it. So that's a more nuanced, take everything into account type of approach. Now,
is there any suggestion that the position on this issue, which is the role of the Court of Appeal in relation to findings of fact by the first instance judge, should be any different in judicial review cases from the general one of civil cases?
my lord, I don't suggest it should be different in principle, but its application may be somewhat different.
Well, no,
because
that's not a point against you, it's actually a point in your favour.
Yes.
Because I mean the leading authority that I always refer to, and most people do, is the Assicurazione case with Sir Anthony Clark when he was Master of the Rolls. And he does make the point that you're making, which is there's a great deal of difference between the powers of intervention or the appropriateness of intervention by the Court of Appeal, where there's been oral evidence and where there hasn't been. In each case is a matter of judgment. So I just, none of these people cite that you just referred to, neither Lord Sumption nor Lord Justice Sales, refer to the Assicurazione case, but that is regarded as the normal statement of principles for the run of civil cases. That's why I asked the question.
Yes, my lord, I'm not.
Is it suggested there's any difference between them?
If it were to be different, it would be different in my favour, for the reason your lordship's given, because oral evidence is extremely unusual in judicial review.
It's just that the language used by Lord Justice Sales is not the language, certainly, of the Assicurazione case. He talks, he's using some slightly different language here and elsewhere.
But in fact, all he's doing is suggesting that it depends on all the facts and circumstances, if one breaks that down.
May I just put down a marker here? There has been an awful lot of recent case law in the Supreme Court on findings of fact in
Yes.
the ordinary run of civil cases. I'm
Yes.
thinking of cases like Henderson, Foxworth, and there's been several before and after that. And my impression is, I may be wrong, but there are cases where this approach has been reaffirmed, even in relation to appeals where the evidence is all in documentary form. In other words, that you can only properly interfere in the absence of a misdirection, where the conclusion is one that no judge could reasonably have reached.
My lord, I would submit that that is putting the matter too high, and certainly higher than Lord Thompson puts it.
Well,
in the...
you may, I mean, it's a matter of opinion whether
Yes.
it's too high. The question is whether that's actually what the Supreme Court has
Yes.
has
Well, my lord,
said. I'm not 100% clear at the moment, but the position is as nuanced as you submit.
Well, my lord, in my submission, the test is the Vol Cafe test, without the OTO's adverbs, and bearing in mind that this is a case where there is only written evidence. And our case is based squarely on the submission that the findings of fact made in this case are unsustainable because the court did precisely the things that Lord Sumption has identified in that paragraph. It failed to take account of relevant material, and it interpreted other relevant material in ways that material cannot reasonably bear. There are two further points I want to make before turning in detail to the facts. The first is that, as my Lord Justice Etherton has observed, I do have to win on all 5 grounds in order to win on the appeal. However, even if the court is against us on 1 or more grounds, we would respectfully invite the court to decide all 5. And the reason I say that is because, as I've already indicated, this is an interim decision. It applies only to those who retire up to April 2021. The Treasury will shortly have to consult on and decide on a longer-term policy for pensioners retiring at dates after April 2021. And in our submission, the effect of the errors of law made in relation to construction, improper purpose, and property rights is such that unless those errors are corrected by this court, the Treasury will make its decisions on an erroneous belief as to the scope of its powers. There is a final, more general point, which is that we do submit that on at least 2 of these issues, the approach taken by the Divisional Court in this case is startling. The decision made by the Divisional Court on improper purpose is novel and highly unorthodox. It has the implication that where a government is pursuing a public policy which can be fully implemented without adversely affecting a private party, it is improper for it to choose a route lawfully open to it, which will avoid that impact, over a route also lawfully open to it, which will have that impact. Now that, we say, is quite clearly not the law. And it's very surprising to find the government actively seeking to persuade the court that it is the law, because its effect, if correct, would be severely to constrain the exercise of government powers in many different contexts. And secondly, we submit that the scope of the doctrine of substantive legitimate expectation amounting to a property right under Article 1 of the First Protocol, adopted by the Divisional Court in this case, is both novel and clearly incorrect. So what I want to do now is to look at the facts and the evidence and the history of the case by reference to the documents, and having looked at the documents in some detail, to make my submissions on the first 2 issues, which are essentially founded on the evidence, and I will then make my submissions in turn on each of grounds 3, 4 and 5. So let's turn to the facts. So on ground one, our submission is first that the only permissible conclusion on the evidence before this court is that BT was suggesting that the PCSPS amendment route should be adopted, whether or not the statutory override proposal was also adopted. It is certainly correct that BT's preference, indeed its strong preference, was that both the PCSPS and the statutory override routes should be adopted together. And the main reason for that was that BT considered that that would provide it with greater legal certainty than the PCSPS amendment route alone would afford it. But it does not follow from that that BT's position was that if the government concluded that it ought not to adopt the statutory override, BT would not wish the government to pursue the PCSPS amendment route. Taking that approach would imply that BT's preference was that instead of there being some residual uncertainty as to whether or not it would face a liability of 120 million, it was preferring to have absolute certainty that it would face a liability of 120 million. My Lord, in our submission, that is not a sensible interpretation of BT's position, and it is not what the documents show. Secondly, we submit that in any event, the evidence shows that, and this is really beyond any shadow of a doubt, that the government understood perfectly well that that was what BT was proposing. And the government said so repeatedly, both internally and externally, and in evidence to this court, until its volte-face 1 week before the hearing of this case. That's our submission on ground one. Our submission on ground two is that the evidence shows that the decision was made for three closely interlinked reasons. And the primary source for this is, of course, the decision document itself, which I'm going to come to somewhat later. First, the government rejected the PCSPS route because it considered it to be ultra vires. Second, the government considered that all BT's alternative proposals were inappropriate because they would deprive BT Pension Scheme Section B members of indexation to which they would otherwise be entitled. And those words are important. Deprive of indexation to which they would otherwise be entitled. And third, that the government considered that that entitlement was a possession or property right for the purposes of Article 1 of the first protocol, so that interfering with it would be unlawful unless justified. On that basis, if the government was wrong, as we say it was, about vires and property rights, the decision cannot stand.
So what was the first of those again? So it's catching up.
So the first was vires, the PCSPS amendment route was ultra vires.
That's fine.
The second is inappropriate because it would deprive of indexation to which otherwise entitled. And third, deprivation of that entitlement is an interference with property rights. And our submission is that the policy view about the inappropriateness of BT's proposals is inextricably linked to the characterisation of the members' interests as an entitlement amounting to a property right. What the government was doing was weighing the interests of BT against the interests of the scheme members. And that weighing could not lawfully or rationally be undertaken if the nature of the interests was misunderstood. If in fact the members did not have a property right or a legitimate expectation or an entitlement, but merely a hope of a future benefit to which there was no entitlement, then the weight to be accorded to their interests would, or at least might, be significantly different. So if we're right on the law, the correct weighing exercise has never been undertaken and must be redone. Now, you can characterise that error in a number of ways. As an error of law, as a failure to take account of a relevant consideration, as taking account of an irrelevant consideration. They all amount to the same thing. If the government misunderstood the nature of the interests that were in play, it was not in a position to make a lawful determination about which interests should prevail. Can I now turn to the evidence? And starting with the relevant provisions of the pension scheme itself, this is Supplementary Bundle 2, tab 35, page 415. So this is BT Pension Scheme Section B, pension increases. Any pension in payment will be increased from time to time in accordance with the Pensions Increase Act 1971 and Sections 59 and 59A of the Social Security Pensions Act 1975, as if the pension was payable under the PCSPS. So that is saying that the Section B members have the right to any increase in pension that they would have if they were members of the PCSPS and those increases were made under either of those identified pieces of legislation.
I'm so sorry, Miss Rose, I haven't got the reference to this.
Sorry.
It's in my fault entirely.
Page 415, my lord. 415 of Supplementary Bundle 2, behind tab 35.
Oh, tab 35, thank you. Sorry, I think I'm the wrong way around. 415, yes.
415.
Absolutely, thank you.
So if PCSPS members are being given an increase under this identified legislation, that increase will read across to the BT Pension Scheme Section B members. What this is not saying is if PCSPS members have a right to an increase under any other legislative provision or any other rule of the PCSPS, that BT Pension Scheme members will be entitled to that increase. It's limited to that legislation.
Well, and I think that's the point which is not going to be decided.
Well, the position is, my lord, that that interpretation was not challenged by the government in the consultation process, and the agreement between the parties is that beneficiaries are not precluded from challenging it in future proceedings, but that for the purposes of these proceedings, there is no alternative that's being advanced. And that it certainly was no part of the government's case that BT was wrong in that construction. In other respects, the BT Pension Scheme Section B does not mirror the PCSPS. As we shall see in a moment from BT's response to the consultation, there are significant differences between the benefits provided under each. That is very different from the position under Section A of BT's pension scheme. And for comparison purposes, the court has an extract from Section A in the following tab, tab 36. And you see, first of all, the purpose and definitions, Rule 1. The purpose of the rules is to provide that in respect of principal company employment, I'm leaving out the words in brackets, there shall be paid to or in respect of any member or various dependents the like superannuation benefits as the maximum benefits, this is after the parenthesis, which could be paid to or in respect of such member under the enactments and instruments relating to superannuation in the civil service, as hereafter varied from time to time. And what the court there sees is a provision in a pension scheme intending to provide mirroring. and saying, not by reference to any specific right to an increase under specific legislation, but any right that people have under the PCSPS, the maximum benefits under any legislation, the PCS as amended at any time, will be also an entitlement to the BT pension scheme section A members. And that's then reinforced if you go to Rule 6, page 422, choice and basis of benefits. A member may choose between the benefits payable under the PCSPS and the benefits payable under the PCSPS as adjusted by Part 4 of these rules at any time before the earlier the date that they leave service and the date of benefits payable. And then if a member does not notify the trustees of his or her choice, the trustees will treat the member as if he'd chosen the greater of the two alternatives. So it's very clear that under Section A you get the maximum that you could get under the PCSPS. That's very significantly different from Section B.
Can you just tell us, by way of background, who falls within A and who falls within B?
It depends on retirement date, my lord. I think the key cut-off date is 1971. Somebody will tell me if I'm wrong.
And I can deal with that in some more detail.
Yes. I'm told that the trustee can give you some more
Probably
information.
was in the skeleton, but I can't remember.
So that's the key provision of Section B and the key difference between it and Section A. So now we come to the course of events and we pick up the story in early 2016. So this is after the enactment of the Pensions Act 2014 and after the government has realised that it's made commitments historically to members of public sector schemes which will have to be honoured in the light of what's going to happen in April 2016 when the new pensions legislation comes into effect. And in the spring of 2016, the government announced that as a short-term measure, it was going to introduce a direction or a ministerial direction under Section 59A on an interim basis to plug the gap. And it was around this time that BT started to actively engage with the government on this issue. So if you take up Supplementary Volume 2, it's page 225, behind tab 15. And this is a letter from BT to the Treasury, and you can see, if you just look at 224, that this was sent under cover of an email dated the 11th of February 2016, and that it followed a recent meeting, as discussed at our recent meeting and earlier this week. I've attached a letter setting out our initial views on ways to mitigate the potential unintended consequences if the government were to decide that public sector schemes should fully index GMPs. So this was the initial view of BT. And what the court could see at 225 is that, first of all, BT expresses its concern about a ministerial direction and that will have very significant knock-on effects on BT. And just below the second hole punch, they say, we welcomed your comment at our meeting that the Treasury recognises this as an unintended consequence and is open to exploring ways to mitigate this. Doing so would be consistent with the government's stated intention that private sector schemes will not be required to replace the GMP increases that are currently provided by the state. And then they say there are various ways whereby the government could achieve an objective of fully indexing GMP increases for public sector scheme members without increasing the burden on private sector schemes. We'd be happy to meet again to explore potential options with you. And they then discuss some options which at that stage do not include the PCSPS amendment route. On the 1st of March 2016, the interim decision was announced, and the court has that at tab 17, it's at page 244. So this is the first decision that was not done with prior consultation. It was done on an urgent basis. and that was only up until those who were retiring up until December 2018. And you can see over the page at 245, the government as a large employer, so here we see government acting qua employer, has considered how best to address the implications of changes resulting from the introduction of the new state pension for public service pension schemes, taking into account historical commitments made by previous governments. The government's expected to launch a consultation this year on how to address this issue in the longer term, recognising the increased value of the new state pension and seeking to balance simplicity, fairness and cost to members, public service pension schemes and the taxpayer. So that's an interim decision. It's expressly stated to be to qua employer for honouring commitments to public sector pension and to be followed by a consultation. So then on the 8th of March, a letter was written by the chairman of BT, Sir Michael Rake, to the Chief Secretary to the Treasury, and that is at tab 18. And he says, I'm writing to you to seek your assistance with regard to what is an entirely unexpected and in our view unnecessary cost of £1 billion to BT. There's been a lot of debate about the exact cost. And he says one of the state schemes where you'll continue implementing the GMP increase is the PCSPS. For historical reasons, this has a direct effect on the BT scheme. And then over the page he says this: Treasury officials have indicated to us that the government plans to implement the change to the PCSPS by way of a ministerial direction. I'm requesting that you consider making the change another way, not by ministerial direction, but by a change to the rules of the PCSPS. And so the court will see that is in fact the first occasion on which BT puts forward the PCSPS amendment route. And the court will note it puts it forward as a freestanding option. It does not put it forward in conjunction with the legislative override or suggest that the legislative override is a necessary element. And we'll come later, there's a finding of the Divisional Court which in my submission cannot stand in the light of this letter. They say alternatively you could consider the state simply continuing to pay the increases directly. We have a QC's opinion that either such approach eliminates the potential incremental cost of the BT pension scheme. I should be most grateful if you could give urgent consideration to this request. We're told the decision is imminent. It seems he may not have realised that in fact the interim decision had already been announced. And so BT are asking to meet, and they tell the government that they have an opinion from a QC, and in fact they shared that opinion with the government, as you can see in the following tab. This is the 9th of March, where you see that Mr. Rogers is sending to the Treasury an advice from Andrew Simmons QC, the leading pensions silk at the time. And at page 254, you can see that he addresses amendments to the rules of the PCSPS. And he concludes that the PCSPS amendment route would avoid read across to BT Section B scheme members. And you can see his conclusion at 3.6 over the page. Again, that being advanced as a standalone option. That was then considered internally by the Treasury on the 17th of March 2016. It's a memo that's misdated 2015, and it's at tab 20, a submission to ministers. And at 258, you see at paragraph 4, they identify the two proposals being made by BT, which are one, changing the PCSPS scheme rules, And 2, an alternative delivery approach that would see these payments be made through the state.
Which page are we on now?
Page 258, my lord, paragraph 4. So again, complete understanding of the nature of the proposals. And then this, at 5, from a policy perspective, the BT Group are right that the intention of this policy was not to impose a cost on the BT pension scheme, but rather to deal with an inequality in the public service schemes. However, having considered both of these options, we have reservations from a policy and legal perspective. Taking each in turn, civil service rules option. Then there's a redacted portion that says the government doesn't have the legal powers necessary to deliver this option. So there is the vires reason given as the first reason for rejecting it. Further, it's possible the government or BT made commitments to these private sector employees at the point of privatisation. That suggestion was not ultimately relied on by the government. You'll see in a moment BT stated in its response to consultation that there had been no such commitments, and the government didn't suggest otherwise. And then in that context they say it's not clear the government should deliberately craft the relevant legal instruments to deprive the affected members of the BT pension scheme of the rights they would otherwise have been entitled to. Now, what's significant there is you can see there the genesis of what later become the key reasons for rejecting this proposal. But the entitlement language there is used, and we say correctly used, in a context in which it's being hypothesised that there might have been express commitments made to BT pension scheme members at the time of privatisation. It's not suggested that any entitlement would derive simply from what the government had done in the intervening years, which is now the position that's being adopted. Finally, while we expect most other mirror schemes also mimic the PCSPS, it's possible a solution that works for BT might not work for other mirror schemes, including because they mirror a different public service pension scheme. That concern later evaporates, as we shall see, because in fact BT are the only people who are adversely affected by this and who are not prepared to implement it. So that's the internal consideration. And there is then a meeting which takes place on the 21st of March. And if you go to tab 21A, this is an email from the Treasury to BT on the 21st of March. Thanks for your time this morning at such short notice. I think it was a really helpful meeting. I agreed in the meeting to send you the detail of why the option of amending the PCSPS isn't feasible. I've set this out below. And there you then see a summary of the vires argument, based on the proposition that there are two separate schemes, and an outcome under current primary legislation. There is no power to amend the PCS scheme rules, so indexation is payable under those rules rather than under the PIA.
Sorry, I didn't see that. Where is that on?
It's at the bottom. You see, at the bottom of the page it says outcome, and there are two bullets. And that's the vires argument. And BT responded to this email. If you just go back to tab 21, there's an email from Mr. Rogers. Thank you for arranging yesterday's meeting and setting out the detail of your analysis on the PCSPS rule amendment option. We've considered this further with fresh fields, remain of the view this option is feasible from a legal perspective. And they then set out a detailed legal analysis of why they don't accept that there's no power to amend the scheme rules. And what's said there by BT remains essentially our case in relation to issue 3. And you can see that over the page they make insertions in the body of the email we've just been looking at, rebutting the various points made. We don't need to go through it in detail, but that's a detailed engagement with the law on the vires point. And then at the top of the page, on the 23rd of March, in view of the different legal opinions, we're willing for you to take an independent QC opinion on this matter and we'll pay for the costs. So BT is saying, if you, the government, want to take independent QC's view, we'll pay for you to do that.
Which page is that? That's
at the top of page 264, my lord. And the response to this is a letter to Sir Michael Rake, the chairman of BT, on the 24th of March, so that's the following day, which is at tab 22. So they say that they thank him for his letter of the 8th of March, and they say, we asked our officials to set up a meeting with your colleagues to allow you to discuss this important issue further. We hope this meeting would clarify the extent of the policy announcement, as well as providing an opportunity to have a detailed discussion of the proposals you've made in your letter. We understand it was a very helpful meeting with a broad consensus reached on how we can move forward. And I stress those words, how we can move forward. Specifically, Treasury officials set out the reasons we're of the view the proposals from your letter cannot be taken forward, and officials have shared the detailed legal analysis with your colleagues to allow them to consider. However, it was also agreed further work must be done to look at ways for the government to support schemes like BT where they decide to no longer follow the indexation provisions of the public service pension schemes. We've asked both Treasury and DWP officials to continue discussions with your colleagues and keep us informed of progress. Though the finer details have still to be worked through, we believe one option would be for this to form part of the government's consultation on the long-term solution to GMP indexation and equalisation for public servants. And then they explain that this is the decision made so far is only a short-term one, and then they say at 6, we look forward to continuing to engage with you on this and want to thank you for highlighting this issue. So the upshot is that after considerable detailed discussion of the PCSPS amendment route, what they're saying is this can go forward to the consultation about the longer term outcome. And what then happens is that the government publishes its consultation paper. And the consultation paper is at Supplementary Bundle 1. And it's tab 1 of that bundle. Now this document's important not only for issues 1 and 2, that of course are my primary focus at the moment, but is also important in relation to issue 5 on the question of whether there could have been any substantive legitimate expectation. Because part of our submission is that in fact the only remotely comparable administrative order or direction that had ever been made was the one made in 2016 on an expressly interim basis. And that is then followed by this consultation, which makes it clear, it's made clear in the announcement itself that it's only interim, as we saw. And then this consultation makes it clear that going forward for the longer term option of indexation of GMP, all options are on the table. And in my submission, it is impossible to suggest that any BT pension scheme member could have thought that there was any expectation that the government would only index GMPs of PCSPS members through section 59A after reading this consultation. So here is the consultation paper, and its purpose is summarised at the bottom of page 3 at paragraph 1.2. It's number 2. They're consulting on another issue here about equalisation, which is not material for our purposes. And pages 4 to 5 deal with the options. And you see a summary there of 3 different options, case by case, full indexation and conversion. And then it says other methods. The government is also interested in views on solutions other than the 3 above, that would address the indexation and equalisation issues brought about by the introduction of the new state pension. And just below the second hole punch on page 5, the government also understands that some private sector occupational pension schemes may be affected. Such schemes include those whose trust deeds and rules explicitly require them to follow the indexation treatment of the public service pension schemes, including provisions of the PIA and the Social Security Pensions Act 75. The government is interested in understanding more about the private sector pension schemes who mirror the public service schemes for GMP purposes, in order to understand how the proposals set out in this consultation might affect them. We say this is also relevant to improper purpose. It's really hard to see, in the light of that policy, how it could be said to be improper to do the very thing that the government is asking consultees to consider, in a context where the government's policy is intended to be targeted at its own public sector scheme members, to whom specific assurances were given. Then, if we go to page 9, between the hole punches you see an acknowledgement that this is about the commitments that were made by previous governments since the time GMPs were first planned and reflected in the legislation. And that's the basis of this policy. And then page 14, you see the heading Policy Intent, 2.5 Policy Intent. And the second paragraph, the government's considering how to meet the past commitments of previous governments to fully price, protect public service pension payments, including the GMP. And then at page 21, wider considerations, alternative solutions. The government recognises there may be alternative solutions to deliver the government's objectives in relation... Page 21, my lord, at the bottom. Government recognises there may be alternative solutions to deliver the government's objectives in relation to indexation and equalisation of the GMP. For example, implementation of a time-limited full indexation approach paired with removal of the 3% cap on indexation on post-88 GMP. Government's interested in views from respondents on whether there are alternative options not considered in the main body of this consultation document that would meet the government objective of avoiding unequal pension payments to men and women, and which at minimum protect those who lose out in the transition to the new state pension as a result of no longer receiving indexation on their GMP. And then impact on the wider public sector and private sector. Government recognises that for some private sector organisations and wider public sector organisations, the way any of these policy options are implemented is relevant in determining whether it would impact on their pension scheme. We're keen to hear from such organisations and representatives. We wish to understand how their rules align with those of the public service pension schemes, whether the government should take action to avoid a read across, and if so, what specific actions they feel the government could take to avoid direct implications for their pension schemes, including which policy options will be expected to directly require changes to such schemes. And again, my submission, that is a fair summary of the purpose for which BT was inviting the government to implement the PCSPS amendment route. It's impossible to see how that's improper. So that's the consultation paper, and then BT responded to that consultation in the following tab 2, on the 20th of February 2017. And the court will bear in mind that BT's consultation response here follows on from the very close engagement that BT has already had with the Treasury, both at meetings and in an exchange of written views and in the provision of a legal opinion. So this is not a single document to be read in isolation. And as we'll see in a moment, one of the key flaws in my submission in the Divisional Court's approach to issue 1 is that it treats this document, construes it entirely in isolation, without bearing in mind the engagement of which it forms only one part. So BT set out their summary at the front, and they say there are steps, they say that there could be an unintended adverse effect on BT, and there are steps government could take to prevent those unintended consequences. See paragraph 1.11 below. And it's paragraph 1.11 which forms the centrepiece of the Divisional Court's reasoning on issue 1. So that's at page 27. In order to prevent substantial, unnecessary and unjustified costs arising in respect of private sector employers, we request that the Treasury makes certain adjustments to its proposals. And the first is the statutory override, and then it says, and either implementing full indexation or the case-by-case option to an Act of Parliament other than the increases legislation, or an amendment to the rules of the PCSPS, or the conversion method. So it's right to say that their request is the legislative override and either PCSPS amendment or some other solution. But it is clear that they are not saying we only want the PCSPS amendment if we have the statutory override. Why do I say that's clear? Because it's clear when you look at the rest of the body of this document. So if you go over the page at 28, BT explains the background, and it explains the differences between section A and section B. At 2.6, the court will see the point I made, that there are now significant divergences between the benefits provided under section B and benefits under the PCSPS. And then at 2.8, as noted above, whether section B would be impacted by government's chosen option in respect to the PCSPS depends on how any such option is implemented. This is because the section B pension increase rule imposes a requirement on the BT pension scheme to apply PCSPS increases only where those increases are required by sections 59 and 59A. Then they give an example, and then at the bottom of that paragraph, had the implementation method been, e.g., an Act of Parliament other than the increases legislation, or a PCSPS rule amendment, see section 3 below for further detail, this unintended consequence should have been avoided. So they're making it clear that it's because of the ministerial direction under 59A that BT is adversely affected, and that could be avoided either by other primary legislation or by the PCSPS amendment route. And then you see the heading, Impact of the Options Proposed in the Consultation on the BTPS. We've explained below how government could implement the policy options in such a way that avoids the unintended consequence on section B. Option 1, full indexation. So this is the government's first option. As explained above, if a full indexation requirement was implemented through a new or amended ministerial direction under 59A, the BTPS liabilities would increase by around 600 million. However, if continued full indexation was implemented through an Act of Parliament other than the increases legislation, our view is that the section B pensions increases rule would not be triggered. For example, if continued full indexation was required under a new statutory regime via a new Pensions Act, or by regulations or order under existing primary legislation other than PIA 71 or SSPA 75, there should be no consequential unintended additional funding impact. In a similar vein, implementing continued full indexation through a PCSPS rule amendment rather than via legislation would also avoid the unintended section B impact. And then they say this, that said, The legal analysis is likely to be complex, and there could be differing views on how the Section B pension increases rule should be interpreted, with the potential need for clarificatory court proceedings. This approach may also not work for other affected private sector schemes, depending on their scheme rules. Given this legal uncertainty, we would urge government to also introduce into legislation a statutory override. So what BT is saying is, we think you can avoid the adverse effect on us by the PCSPS route, but we accept there's some uncertainty, so we urge you also to introduce the statutory override. That is very different from BT saying to government, if you're not prepared to introduce the statutory override, we want you to do it through a ministerial direction, and we're not suggesting PCSPS amendment route because we're happy to take the certainty of the hit. So we submit that paragraph 1.11, saying our request is for both, is explained when you look at paragraph 3, which makes it clear exactly what BT is saying. And to interpret it otherwise, as I've already submitted, would mean that BT was adopting an irrational position of preferring the certainty of an adverse consequence to the probability of the avoiding the impact. You will also see in this document, before I leave it, that at 3.8 and 3.9, BT addresses the question whether assurances were given to BT pension scheme members. And it says that they've conducted an audit of the communications sent by BT to its employees at the time the pension scheme was set up. Based on our audit, nowhere was it promised by BT that the Section B indexation basis would always mirror the PCSPS. Similarly, not aware of BT or the BTPS ever having made specific assurances to Section B members in relation to the continuation of increases of GMPs. Now, whether individual members, vis-à-vis BT, at some future date want to take issue with that and say we think assurances were given and we have a legitimate expectation as against BT that our GMP will be fully indexed, is nothing to the point. The question is whether the government, on the basis of the information it had, reacted lawfully to these proposals. Now, we can see the way the Divisional Court reacted to this material if you go to the judgment at Core Bundle 5, Core Bundle tab 5, and it's paragraph 118. Page 58. And this is really the entirety of the Divisional Court's reasoning on this point. They say it's clear from the BT consultation submission, considered as a whole, that the statutory override was put forward as a necessary element of BT's alternative options, essentially for the reasons given by the Treasury. Paragraph 1.3 makes it clear the steps the government could take are those at 1.11. 1.11 clearly and unequivocally proposes that there be the statutory override in addition to one of three possible options. 3.2c provides compelling reasons for including the statutory override. What is noticeably missing from there is, first of all, 3.2b, in which BT explained why it wanted the PCSPS override amendment route and why that would avoid an adverse impact on it, and consideration of this document in the context of the engagement that BT had already had with the Treasury that we've looked at. That's not considered at all here. This document is treated as if it landed on the Treasury's desk without them having the faintest idea of what BT's views were. Now we say that that is wrong, and it's then compounded by a further error, which is that the Divisional Court concludes that the Treasury understood that BT was only asking for the PCSPS route coupled with the statutory override. And we say that that is demonstrably not correct from the contemporaneous documents and the evidence. And the starting point for that is the government's submissions to ministers addressing the responses to the consultation. And there are two submissions to ministers, one in October 2017 and the more centrally relevant one in November 2017. And we find these in Supplementary Bundle 2. And the first is at tab 24. So this is the October submission to ministers. What happened was that civil servants recommended to ministers that they should make a decision in two stages. First of all, they should take an in-principle decision as to whether to go for an interim full indexation route or for one of the alternatives such as case-by-case or conversion. And then, in a later decision, decide whether to use a method of full indexation that was being put forward by BT. So they essentially shelved the question of the method of imposing full indexation until the second stage of decision making. And you can see this in the October submission, which is mainly devoted to explaining why the conversion option, whilst it's a better option, is too difficult for the time being. And at page 279, you see the heading Private Sector Impacts. There would be potential impacts for some private sector funded schemes which mirror public service pensions increase provisions. These include workforces in previously nationalised industries, including BT and British Airways, and others such as the University Superannuation Scheme. Before the introduction of NSP, the cost of providing full indexation fell to the state, up to 3% CPI, etc. Full cost now falls to private sector schemes which mirror public service indexation requirements. BT's estimated that either conversion or full extension of the current solution would add an additional 600 million to their total scheme liabilities, a figure we question. To prevent this cost to scheme, BT has requested that we consider a statutory override of scheme rules, an Act of Parliament, or an amendment to civil service pension scheme rules, which BT mirror. So you can see very clearly there that the officials understand that these are alternatives. And then at 16, Treasury legal advisors have indicated there's a risk of judicial review from BT of our consultation response. Our initial view is that at privatisation in 1984, it was the policy intent that the rights of BT employees to future pension benefit indexation be protected, regardless of any future changes in the pension system. We're seeking your preliminary and in-principle agreement that we should develop our consultation response on the basis of extending the interim solution with a commitment to look at conversion as a long-term solution. In order to meet our legal obligation to fully consider all responses, a final decision will only be made once all the issues raised by consultees have been fully considered. We will provide further advice on potential private sector impacts. So that's the point about this being the first stage. And you can see that if you go over the page to page 280.1. This is an email, internal email. In the middle of the page, I just wanted to check you were happy with this being phrased as a preliminary policy steer and with the understanding that more advice will follow on BT issues. So it's the November submission which contains that advice. And the November submission is at tab 26. And at the bottom of page 285, you see the heading Impact on BT. Now, this is one of the documents that was originally disclosed to us in a heavily redacted form, but which 1 week before the hearing was produced in an unredacted form that made it much clearer how central the question of property rights was to the advice that was being given. And we can see that here. I'm going to give you an indication of the parts that were originally redacted and later made clear to us. So, paragraph 9, BT, you can see, but before we get to that the other pension schemes that have been mentioned don't present a problem for reasons which are given in those paragraphs. You can see there's a reference to the university's scheme at paragraph 8. So this really is a problem that only really relates to BT. BT has asked us to legislate to exclude Section B members from the obligation in BTPS rules to index pensions in accordance with the legislation governing public service schemes, so that extending the interim solution does not impose additional costs on them. BT argue the current interim solution has already added 250 million and so on. Then the Government Actuaries Department have confirmed the figures as reasonable, as you can see, at paragraphs 10 and 11. And then paragraph 12. BT have suggested a number of solutions for this. 1, a new act. 2, amending the 1974 Civil Service Scheme. Or 3, providing a statutory override. So that's the second time that they're presented to ministers as alternatives. Treasury legal advisors advise that in each case, and I ask the court to underline in each case, so it's not just that these are presented as alternatives, we're now told that the legal advice that's being given relates to each of these alternatives, in each case.
What page is it?
My lord, it's page 286.
Yeah, it's on page 286.
This is the critical paragraph, my lord.
I'm on paragraph 12.
Paragraph 12.
Yes.
So first of all, you see 3 alternatives, clearly expressed as alternatives.
Yes.
The second of which is the PCSPS amendment, and the third of which is the statutory override.
Yes.
And then
So I see TLA advisor.
advise that in each case. So they're clearly presented as alternatives, and in each case, there would need to be a policy justification for preferring the interests of BT to the interests of the scheme members. The scheme rules have the result that members are entitled to benefit from a Treasury direction in the same way as members of the 74 Civil Service Scheme, and there would need to be a legally defensible justification for interfering with BT scheme members' property rights. Now, that last sentence, the scheme rules have the result, down to property rights, was originally redacted. In my submission, there's only one way you can read this paragraph. What is being said to ministers is BT have put forward 3 alternatives. Each of these requires justification, and the reason is that each of these would interfere with property rights. And now, in my submission, there just isn't any other way of reading that. They then go on to say there are significant legal issues with the first option BT have put forward. The first option is a new act, and there's then discussion of those. Then at 13, Treasury legal advisors advise that it may be possible to devise a mechanism to avoid impacting on schemes such as BT, e.g. if the Secretary of State agreed to make negative resolution regulations under Section 67. However, that would require identifying a legally defensible justification for the interference in property rights, a justification which we would test with counsel in light of the difficulties outlined above. there is no guarantee we could develop a defensible justification. So again, what they're saying to ministers is there might be ways to index for public sector pensioners without there being a read across to BT, but they would all interfere with property rights and therefore unlawful unless objectively justified. Again, that was redacted in this document originally. Then at 14, in addition, there would be practical and presentational issues. So that is an add-on to the primary concern, which is the interference with property rights. And then at 15, again, the whole of 15 was originally redacted. Legal risk is high. A judicial review brought by members of trade unions is likely, and unless we were able to develop a defensible justification for interfering in property rights, there is a high risk of the judicial review being successful. In my submission, we're looking at a decision made on the basis of this internal submission to ministers. And in my submission, you cannot say that the understanding that any of the solutions proposed by BT, including PCSPS, would interfere with property rights is not a material factor. It's up front and centre. It's an impossible interpretation of this document. And of course, it's not for any official to come along and say how he understands this document, because this is a document that was not for his ears and eyes, it was for the ministers who were going to take the decision, who did not give evidence in these proceedings. And the question of what this document means is a question of objective construction. And then the question is posed to ministers, do you agree that we should extend the government's interim GMP equalisation and take the indexation policy forward to April 2021? Do you also agree to rejecting BT's request for the government to legislate to remove or enable the removal of their obligations under the BTPS pension scheme rules? If not agreeing to, should we work further with DWP on the possibility and implications of a carve-out for BT and seek Council's opinion? So they ask about the legislative override, but then they ask, should we consider other options for a carve-out? But what they've already told ministers is any of the options for a carve-out would interfere with property rights. And that is then followed by the decision made on the 22nd of January 2018. And the decision is in the core bundle at tab 12. And much of this is taken up with an explanation of why the government's making a further interim decision, not a long-term decision, and why it's going for full indexation in the short term, though it thinks in the longer term the better option is conversion. But the crucial section for our purposes is at page 303, where you see the heading Private Sector Organisations. And they say that two schemes, this is 3.17, two private sector schemes with indexation provisions linked to public service schemes responded. And at 3.18, one consultee noted they would honour the requirements of their trust deed and rules to provide full increases to GMP where this is not in effect provided by the state. So they were not a problem. This is a unique problem to BT. The other consultee, and that's BT, requested that the government should craft its response in such a way as to avoid the read across from public service schemes to their private sector scheme. And you can see that that is not being put in terms of the legislative override. It's a general and correct characterisation of BT's position that they were asking the government to craft the response in a way that would avoid the read across by whatever means. And that's consistent with the two questions that were being put to the Minister that we've just looked at. One, legislative override, B, other options. However, and here's the critical passage, these are the reasons for refusing this. The government believes it would not be appropriate to act in a way that would deprive members of indexation to which they would otherwise be entitled. Notice the language there, deprive of indexation to which they would otherwise be entitled. Acting to do so would also raise legal questions, including whether there was a legitimate aim to justify such an interference in the property rights of scheme members. So just pausing there, my submission, it is absolutely clear that the policy argument cannot be separated from the government's belief that there would here be an interference with property rights. The nature of the interest of the scheme member that's being weighed against BT's interest here is said to be an entitlement which amounts to a property right. And then they say, in addition, some of the mechanisms suggested by the consultee to avoid this impact are outside the scope of the government's statutory powers. Now, that's very significant because that is a reference to the PCSPS amendment route. We know that is a reference to the PCS amendment route, firstly because it's obvious in the light of the engagement that we've looked at and the legal views that have been exchanged as between the Treasury and BT, and secondly because the government gave evidence confirming that. That's the first witness statement of Mr. Kirk. It's Supplementary Bundle 1, tab 6, page 127. If you just turn that up. At 127, paragraph 107, you can see he sets out the paragraph we've just been looking at, 3.19, and he says it captured the Treasury's main thinking in a condensed form. Then he elaborates on it, and you can see at B, he says, halfway down B, in addition, at least some of BT's proposals were positively unlawful, in the sense that the government would be acting outside its powers if it took them forward. For instance, the government lacked the power to take forward the proposed PCSPS workaround. BT were already aware of HMT's view on this issue through their communications with BT in 2016. Now, the question I asked the court is, how could it be said, in the light of that paragraph of the decision itself, which is quite clearly not limited to the statutory override, but is looking at any carve-out of BT, and which is specifically referring to the PCSPS amendment route and saying it's rejected because it's ultra vires, how could it be said that the government did not understand that the PCS amendment route was being put forward by BT as an alternative proposal? Every single internal and external government document we've looked at up to the point of the decision, and the decision itself confirms that that was their understanding. And it's hardly surprising that that was their understanding, because it's obvious. And how could it be said that the policy decision that you see at 3.19 can be severed from the belief that this is an interference with property rights, when the entitlement of members is described specifically as a property right? Now, the reasoning contained in that decision itself was elaborated upon in a letter to BT sent on the 14th of February by the Treasury after BT had asked for further reasons. And that letter is at Supplementary Bundle 1, tab 3. It's page 55. So this is in the immediate aftermath of the decision. It's before any proceedings have been issued. And it's specifically intended to give further reasons to BT. And they say at second paragraph, I'm grateful you've engaged so closely with us during the consultation period. I acknowledge this extension will have cost implications for the BT pension scheme, and I understand you'll be disappointed by this outcome. In considering its response to the consultation, the government has sought to balance the interests of scheme members, public sector schemes and departments, those private sector schemes affected by the policy, as well as the taxpayer. So there is an explicit acknowledgement that it's about balancing interests against each other, and that's why we say you can't lawfully balance an interest if you don't understand its nature. You have noted in the government response that we did not consider it appropriate to attempt to craft a policy which removed from private scheme members, including members of the BT scheme, the indexation to which they would otherwise be entitled. I know my colleagues have conveyed to you that we undertook a detailed analysis of your proposals. We consulted closely with DWP on your consultation response and sought legal advice. The specific position we arrived at was agreed with Treasury ministers. We believe that removing the existing obligation of the BT pension scheme to index in line with the PCSPS would be to act against the interests of members. As you've recognised, these members have a property right to indexation. The bar for removing those rights is high. Now that is a reference to the statutory override. Then we go over the page. You put forward several proposals as to how government could deliver its policy objectives to equalise and index the public service GMP, but avoid the impact on the BT pension scheme. One would involve primary legislation providing for a statutory override. Another would be to make changes to the PCSPS rules to provide for indexation outside of the existing statutory framework governing pension increases. All such proposals would involve the government acting against members' interests, and as the consultation response says, the government believes it would not be appropriate to act in a way that would deprive members of indexation to which they would otherwise be entitled. Now, if there were any remaining residual doubt as to whether or not the government treated the PCS amendment route as an alternative to the statutory override, how can it survive this letter? And, my Lord, this letter is not even referred to by the Divisional Court in its decision. It doesn't deal with it. There would, in addition, be legal issues as to whether the high legal bar to removing property rights was met. And they say there would be a significant risk of a legal challenge. So again, you see reiterated in this letter, first of all, the understanding that these are alternatives, and secondly, the understanding that this is about depriving scheme members of an entitlement, and an entitlement that amounts to a property right, and that that's the interest that the Treasury understood was being weighed against the interests of BT.
Well, they're referring to a risk of legal challenge.
Yes. But my Lord, that's supplementary. That's after they've already said, we don't think it's appropriate to favour the interests of BT over the entitlement of the BT scheme members. So independently of the risk of legal challenge, they're saying we've weighed the scheme members' property rights as being heavier in the balance than BT's interest.
Well, the
Yes,
I
that's the
understand-
point, my lord,
I
that it's,
I understand the point you're making.
yes,
But there are a number of reasons that are being amalgamated and put forward
There are.
here. And one of them is about the risk of a legal challenge.
yes.
Now, they don't have to be absolutely right or absolutely wrong about the substantive legal point. The question is whether or not that was at the very least, a reasonable position to them to take about the risk of a legal challenge, wasn't it?
Well, my lord, if that were the only thing that was said, that might have some force, but it's not, because that is being added to the main substantive point, which is, as a matter of policy, weighing the relative interests, we consider that the entitlement to members, which we assess as a property right, outweighs the interests of BT. And my lord, you see that not only in the decision and in these supplemental reasons, but in the paragraphs of the crucial November submission that we looked at a little earlier, where it's very, very clear that the advice being given to ministers was that any of the routes suggested by BT would interfere with property rights. And we say, how can you make that policy balance judgment if you're wrong about the nature of the engaged right?
At the end of paragraph, at the end of page 55,
Yes.
there's a sentence, a sort of penultimate sentence. As you have recognised,
Yes.
these members have a property right to indexation. What's that a reference to, as you have recognised?
That is a reference to the statutory override. BT had recognised that if the government were to legislate to remove, to enable BT to alter Rule 10.2, so if there were to be legislation that said BT can unilaterally amend Rule 10.2 of Section B so as to decouple the indexation rights of its scheme members from increases to the PCSPS under Sections 59 and 59A, that would interfere with property rights. BT accepts that.
Well, can we just deconstruct this?
Yes.
At the beginning of that paragraph, we believe that removing the existing obligation of the BT pension scheme to
Yes.
index in line with the principal civil service pension scheme would be to act against the interests of members. That's
Yes.
correct, isn't it?
Yes, and it's also correct that the next sentence is correct,
They're
that we
separate
accept that
things.
that would be an interference with property rights.
Um,
That's the statutory override.
you were saying the whole of that paragraph is dealing only with the statute,
Yes.
the whole of that paragraph.
Yes, yes. Because what it's talking about is removing the existing obligation of the pension scheme to index in line with the PCSPS.
But is that in fact right? I mean, just bringing about a situation in which, leaving aside legal rights, bringing about a situation in which a present legal right to benefit from any increases generally in relation to indexation is being replaced by something which is less than an absolutely certain right, is plainly acting against the interests of members. That's plain. It doesn't matter if it's a statutory override or otherwise. At the moment, what they have is they have, in the terms of their trust arrangements, pension scheme arrangements, they have an absolute right to an increase to match whatever else is happening elsewhere by virtue of indexation and so on. Anything which reduces that, which BT would want for good commercial reasons, no doubt, anything which reduces that is against the interests of members. Now, I agree with you that obviously there's a balancing, but that proposition is correct.
Well, my lord,
So far
with
as
respect,
yes.
the flaw in that proposition is its premise. That we don't accept that it's right that the effect of Rule 10.2 is to give to the Section B members a general right to benefit from any indexation of the PCSPS. The effect of Rule 10.2 is to give to the BT Section B members the right specifically to the mandatory minimum indexation of the PCSPS that is required by the 1975 Act. It does not entitle BT pension scheme members to other rules that result in pensions increases that might be introduced into the PCSPS by other routes, for example, as a result of the government deciding to honour specific assurances given to members of the PCSPS by amending the rules of that scheme.
Yeah, I understand what you're saying. All I'm saying
Yes.
is what BT want here is a replacement of an absolute right to a minimum increase
Yes. No, my lord, they don't want it replaced.
by something else which will not give that automatic minimum increase, but something which is different.
No, my lord, they're not asking for anything different. They're not asking for anything different. All that they're asking under the PCSPS amendment route is that Section 10.2 continues to operate, that Rule 10.2 continues to operate in accordance with its terms. BT Section B members continue to have their entitlement under 10.2 to the mandatory minimum, but that the government, when honouring its own assurances to its own scheme members qua employer, when it decides to give them a top-up indexation of the GMP, it does it through the scheme rules and not through the pensions increases legislation. That's all. And that doesn't have any effect on the scope of BT scheme members' rights.
But I thought this was brought about by virtue of the complaint is the operation of Section 59, of Section 59A.
Well, it's not the operation of Section 59A, it's the decision of the government to use Section 59A to make a ministerial direction giving full indexation to all public sector pension scheme members. And we say that's an inappropriate use of 59A. That's the point. I'm going to come to the statutory scheme.
I'm not sure, it's
Yeah.
entirely my fault. I'm not sure that I understand the difference that you're making.
I understand, my lord. I'm going to deal with that in detail when we come to section 3. Issue 3. At the moment, I'm really focused on the first two factual points. And what I'm seeking to persuade your lordship is that it's not right that BT never put forward the PCSPS route as a freestanding option. It's certainly not right that the government understood that it wasn't being put forward as a freestanding option. They understood it and it dealt with it that way. And neither is it right to say that the government's policy decision to reject BT's proposals was separate from its conclusion that what BT was proposing would interfere with property rights. Those are the propositions that I'm seeking to establish. Now, not only we say that those propositions are very clear on the face of the contemporaneous documents that we've just been looking at, and indeed, the defendant's own evidence was to the same effect until its late volte-face. And if you look in particular at the second witness statement of Mr. Kirk for the Treasury, that is in Supplementary Bundle 1 at tab 10, so this is the 24th of September 2018. You go to page 178. You see the heading, BT's proposed PCSPS workaround, which is what they call the PCSPS amendment route. And he here addresses a complaint that BT had made in evidence that this proposal had never been put to ministers. And he says it's not true, it was put to ministers. So if you look at paragraph 6, as I explained in my first witness statement, in 2016, Treasury officials had explained to BT their view that it was not legally possible to adapt the PCSPS rules in the way BT suggested. BT nevertheless put this suggestion forward again, along with others, in the context of the consultation. Mr. Rogers contends that the PCSPS workaround was never properly put to ministers in 2017. This is wrong. It was clearly put forward to ministers on the face of both the October and November submissions. Neither of the submissions rules this proposal out. following the policy steer provided by the Chief Secretary, the Treasury had no cause to advise on the feasibility of the PCSPS workaround because ministers did not wish to do anything actively to avoid the BT pension scheme read across. Were ministers minded to offer BT a carve-out, the Treasury would have reviewed the PCSPS workaround further, together with BT's other proposals and any other options which may have come to mind. Now, my Lord, in light of that evidence, how can it be maintained or found by the Divisional Court that that option was not put forward, was not understood as being put forward, and wasn't being ruled on by the Treasury? Now, what then happened was their volte-face in Mr. Kirk's third witness statement, served with the unredacted documents on the 29th of October. And it's in particular paragraphs 19 and 20 of that statement at page 186. I don't propose to look at them in detail. My submission is that what's said in those paragraphs is inconsistent with the documents we've been looking at and inconsistent with Mr. Kirk's own earlier witness statement. It doesn't end there, because it also came to light on the 29th of October that there had been a flaw in the legal advice that was given to the Chancellor of the Exchequer, whose duty it was to give the final sign-off to the decision. And as a result, without further consultation, the matter was put to him again on the basis of revised legal advice, and he was asked to reapprove the decision. And we see the revised advice. It's at the core bundle, and it's tab 13, page 313. So just to put this document in context, this is of course months after BT had issued its claim for judicial review, had served its detailed statement of facts and grounds and its evidence, and it's 1 week before the substantive, the rolled-up hearing is due to be heard by the Administrative Court. So by this stage, the Treasury know beyond any shadow of a doubt that BT's complaint is the rejection of the PCSPS route, because that's the basis of the judicial review.
Yes.
And at 313, they say BT requested a legislative carve-out for its pension scheme, and they quote paragraph 3.19. Then BT are judicially reviewing the decision not to provide a carve-out. Unfortunately, the short summary of the CST's decision you were given was incorrect. We need to ask you whether you still agree. The advice you received said this: we recommend against providing an exemption. We would be criticised for reducing former public sector workers' pension rights, and the legal bar for interfering in accrued rights is high. Were we to agree an exemption for BT, legal advice is that the risk of challenge is high and the chances of successfully defending such challenges are low. The underlined sentence was an inaccurate summary of the legal advice. It should have said this: were we to agree an exemption for BT, legal advice is that the risk of challenge is high and the chances of successfully defending such a challenge are low, unless we were able to develop a defensible justification for interfering in the property rights of pensioners. CST decided not to commission the further legal work necessary to test whether a legally defensible justification could be developed. Now, my Lord, in my submission, that is the final confirmation that the policy judgment here cannot be divorced from the understanding and indeed the conclusion that what BT was proposing was an interference with property rights. Because that's the basis of the revised legal advice being put to the Chancellor of the Exchequer long after this judicial review has been brought. So, in summary, my lords and my lady, on issue 1, we say that the contemporaneous documents that I've shown the court show that BT was advancing the PCSPS option as an alternative, not solely in conjunction with the statutory override, and that the Treasury were fully aware that that was the case. That appears first from the engagement and communications that took place before the commencement of the formal consultation, including the correspondence with Sir Michael Rake, the meetings, the memoranda and the exchange of legal advice. Secondly, from BT's consultation response itself, read as a whole, and particularly paragraph 3.2b. Thirdly, as a matter of common sense, that the position suggested by the Divisional Court would be absurd. Fourthly, from the wording of the internal submissions to ministers, both the October and the November submissions, and it's not just the use of the disjunctive or, it's also the specific reference in November to each of the options. Fifthly, the wording of the decision itself. Sixthly, the wording of the additional reasons provided to BT on the 14th of February. Seventhly, the evidence of Mr. Kirk. And finally, the advice given to the Chancellor of the Exchequer. And we submit that the Divisional Court's decision on this is unsustainable. Let's have a look at it now. It's at Core Bundle, tab 5. It's paragraphs 114 to 124, pages 58 to 60. We've already looked at paragraph 118, and the court has my submission on the flaws in that paragraph, that it takes BT's submission as if it was not provided in the context of earlier engagement, and it relies heavily on paragraph 1.11 without looking at paragraph 3.2 in particular, which elucidates what BT mean. The Divisional Court then go on to reject the proposition that the Treasury understood that BT was putting forward the PCSPS override as a standalone option. And you see that is at paragraph 121. And at 122, the Divisional Court seeks to address what's said in the October and November submissions, and the use of what they call the use of the disjunctive or. And they said that needs to be considered in context. The email indicated it was HMT's understanding BT was asking for a legislative carve-out. That term's not defined. It may have been being used loosely to encompass all of BT's various options. It obviously includes the statutory override, to which we reply, well, so what? That doesn't really assist. Secondly, the recommendation made was for the Chief Secretary to agree not to legislate. That is not complete. As you will recall, there were two questions being asked, one about legislation and one about whether any other method should be found to give a carve-out. Thirdly, paragraph 9 referred to the fact BT has asked us to legislate, to which we say, so what? That is true. BT had indeed asked them to legislate. Then the body of paragraph 12 highlighted legal issues relating to the statutory override. Well, it did, but it also highlighted legal issues relating to the other proposals. And in the paragraph that we've been looking at, it specifically said that each of the proposals would involve an interference with property rights. The fact that it also deals with substantive legal issues relating to the statutory override is neither here nor there. The question asked at paragraph 18 was whether to agree to reject the request for legislation. Again, an incomplete reference to what was asked at paragraph 18. Ignores the second part. And the answer given was agrees not to legislate. And then they say this, in our judgment, when the November submission is considered in context and as a whole, it shows that the Treasury reasonably understood that all BT's proposed options involved a statutory override and the need to legislate. If so, the Treasury cannot be criticised for approaching the decision on that basis. And the court will see there is no reference to the earlier materials, there is no reference to the wording of the decision, there is no reference to the explicit addressing of the individual options in the 14th of February document, and there is no reference to the evidence of Mr. Kirk. Now, with great respect to the Divisional Court, that is a wholly unsustainable finding of fact, whatever legal test you want to apply. It's interesting that at 121, they say, reliance was placed on a passage from Mr. Kirk's statement, which was said to be of similar effect. Although it was BT's case, it's the documents rather than after the event rationalisation from officials which matter. But with great respect, the Divisional Court misses the point. It's one thing to say that the government cannot beef up its case by an ex post rationalisation seeking to defend its decision on bases that were not in its original decision-making process. It's another thing to say that where a government official has given evidence that supports BT's case, that what BT says was the understanding of the Treasury was in fact the understanding of the Treasury, that is material that a court can disregard. And there is no consideration at all of the point here that by October 2018, when the Chancellor of the Exchequer was asked to reconsider the decision, the government was in no doubt whatsoever that what BT was asking for was the PCSPS amendment route, and it still referred to it in that memo as a carve-out. So those are our submissions on issue 1. I'd like to deal briefly with, I think I can deal fairly briefly with issue 2 before the lunch adjournment, and then we can have a clean start on the law at 2 o'clock. So we say that it is clear, both from the submissions to ministers, particularly the November submission, and the reasoning in the decision itself, that the decision to reject each of BT's options on policy grounds cannot be separated from the belief that all of those options, including the PCSPS amendment route, would interfere with scheme members' property rights. And we rely in particular on paragraphs 12, 13 and 15 of the November submission, which we've looked at. Those are at Supplementary Bundle 2, page 26. We don't need to go back to them. And we also rely on the express, clear advice given to the Chancellor of the Exchequer at Core Bundle 13, 313-4. We also rely on the reasoning at paragraph 3.19 of the decision, Core Bundle tab 12, page 303, which we've just looked at. And we say all of those are of a piece, that the policy decision was based on the belief that in one side of the scales was an entitlement that amounted to a property right. And the Divisional Court's decision on this is at Core Bundle tab 5, pages 60 to 62. It's paragraphs 125 to 136. And the core reasoning is at 129. The court says, we accept the Treasury's case on this issue, giving a fair reading to the consultation response on the November submission which led to it, and with which the Chief Secretary agreed. The policy reasons for refusing to implement the PCSPS workaround were both separate from the concerns about interference with legal rights and provided the central plank in the Treasury's rejection of the PCSPS workaround. The other points made about interference with rights and acting outside the scope of powers were additional. And they say, in our judgment, there were very obvious policy issues facing the government, regardless of whether BT pension scheme members' property rights were involved. And these were a freestanding basis for the decision reached. Whether or not there was a need to legislate, BT was asking the government to craft a solution to suit its private interests. If the government did so, the consequence would be that Section B members would not get the pension benefits which they would otherwise obtain. Now, just pausing there, can I invite the court to see the very significant difference between the language used by the Divisional Court here and the language used at paragraph 3.19 of the actual decision. There is, with great respect to the Divisional Court, a world of difference between a decision which means that members will not get benefits which they would otherwise obtain, and the decision which means that members will be deprived of benefits to which they would otherwise have been entitled. They are not the same thing. And what the Divisional Court has done here is to seek to elide the two and say it makes no difference whether this was a mere hope or expectation, or whether it was a property right entitlement that already accrued, the policy considerations were the same. And with great respect, we say that cannot be right. And they then talk about this raising self-evident presentation on policy questions. And again, with great respect, when a court talks about something being self-evident, one is suspicious that there may not be a great deal of reasoning behind it.
Very cynical.
It's like when one's opponent says self-evidently, one always knows one's going to be a winner. You will also note that at paragraph 128 of the judgment, the court noted our argument based on 3.19 of the decision itself, where we make the point that the interests of members were described as property rights, such an interference with property rights. That argument was never engaged with by the Divisional Court. They made no ruling upon it. And they made no, and there's no consideration anyway of the fundamental point that you can't weigh interests unless you understand the nature of the interests. So those are my submissions on grounds 1 and 2, and after the short adjournment I intend to turn to the issue which I understand is exercising my lord, which is the statutory powers and their meaning.
Thank you very much.
Surprise.